Helping Seniors Television, all about improving quality of life for seniors. If you're a senior, know a senior, or plan to be a senior, then this show is for you. It's all about helping you develop your own aging plan so you can age actively and with dignity. Helping Seniors Television from the Helping Seniors Network of information, education, and resources.
I am really excited about, we have the Knowledge College of Aging, which is always about helping us get our ducks in a row as we talk about it. In fact, I was smiling at one of the tables yesterday when we were out at the Brevard County Medical Directors Association meeting, and they, in fact, were giving away rubber duckies. I said, I wonder where I've seen this idea before about getting your ducks in a row, because it's so important. And as Ruth and I have had so many conversations on radio and television programs. In fact, we're going to be taping some new television later this afternoon. And Ruth you got to understand this. There's probably a lot of attorneys in Brevard County, but one of the things that we learned is you got to ask the person. Remember, the corollary to getting your ducks in a row is don't try this on your own. And that means getting the right help for what you need at the right time. And so if you call like an attorney, this was literally a story that came up, Ruth, when we were doing radio last time. And you were talking about having to sort out a mess where somebody had gone to literally a criminal attorney. I guess maybe their family knew them and had them put some paperwork together, but at the time it needed to work, it did not work. And so Ruth's office had to get involved and get all that straightened out. And how many know that when you have to do rework things, it gets expensive and time consuming and annoying. And that's exactly why you want to get it right the first time. And so we're always talking about getting your ducks in a row. And Ruth Rhodes is one of only 2 in this entire county board certified elder law attorneys. So the lesson 1 was definitely don't go online and try to do this on your own. Lesson number 2 is don't pluck that business card off of the bulletin board at church or down at the grocery store and think that's a person who's going to help you. And number 3, if you're going to look for a attorney who knows this, who's a specialist in elder law, why don't you get the ones that take the extra time to go above and beyond what's required and become board certified? And Ruth is one of only 2. So grateful for her to come and share with us on today. Ladies and gentlemen, Ruth Rhodes.
So thank you, Kerry, for the nice introduction. I am board certified in elder law, which means that I did have to take additional education requirements. I had to pass a very strenuous test. And I also had to go through peer review, which means other attorneys in the area had to say that I'm A-okay. So I had to go through all that, and I have to continue doing that in order to keep my board certification. So in the packet, I just want to bring to your attention that you do have a business card, and you have common estate planning documents that I'll briefly touch on them. I don't have a lot of time, so I'm going to be talking very quickly. On the back is some common estate planning terminology. We're going to touch on Medicaid planning just a little bit today. I don't see the Medicaid planning handout. Do we have one that I can use? We have our Medicaid myths that we're going to bust if we don't have time today to do it because I have a very limited amount of time, but you can read this at home. Just a handout on why you should use a board certified attorney and notes. So if you have some questions, this is a small group, but I don't have a lot of time. I'm happy to answer questions. My understanding is there's one more speaker after me though. So I don't want to hog up all the time. All right. So today we're going to be talking about the importance of of crisis planning. And for an elder law point of view, we look at crisis planning on providing immediate legal solutions when a elderly client, usually it could be someone who's not elderly, but it's usually an elderly client, where they are suddenly facing a health crisis or the need for long-term care, which is a very nice way of saying probably nursing home care. Okay. Which, as we know, if you have know anyone that's ever been in a nursing home, it's very expensive. Nursing home care in Brevard County is going to cost about $12,000 to $14,000 a month. It's very pricey. So that will very quickly use up most people's nest eggs. And also there's people who are concerned about, I don't want all of my assets to be used up if I have to go into a nursing home. So those are a couple of things I'm going to talk about because that can be avoided if you get the right help. So a elder law attorney's primary objectives in crisis planning are going to be to preserve the client's assets and to make sure they're receiving their necessary health care. We don't provide health care, but we want to make sure you have someone who has the legal authority to help you with that. And we also want to make sure that you have someone who has the legal authority to help make legal decisions for you. Pay your bills, go to the bank, make other types of decisions, talk to the Social Security office, talk to the insurance company, talk to Medicare. You will need to have someone who has the legal ability. And just because you're married doesn't mean anything. You may not be able to make legal decisions and likely won't be able to make legal decisions for your spouse, even if you're married. There are some exceptions for healthcare. You may be able to be declared a proxy, a healthcare proxy, but that's facility by facility. That's not just across the board. So we want to make sure you have the paperwork in place that no matter what doctor you call, hospital you go to, or other type of medical provider, that you can have access to records, information, talk to people, have that HIPAA release. Also, when it comes time to making legal decisions or financial decisions or decisions about assets, want to sell the house, want to help with the banking, that's maybe a bank account that's only in your spouse's name, you need to have a durable power of attorney. You have to, or you're not going to be able to help them. All right, so when I do crisis planning, I take a couple of approaches. I'm going to want to try, if I can, to do some asset protection in the event that they have to go into a nursing home. So I'll do some Medicaid planning, maybe help with some Medicaid planning strategies, and be strategic with planning to meet strict asset and income limits that are under Medicaid. So in order to qualify for Medicaid, you have to have income, and I don't have my chart in front of me, and that should have been a handout here today. Word to the wise, Winter, my assistant back there. I'm going to give you round figures. So the income changes every year. So currently it's around $2,849 a month, I believe, is what the income limit is. That's really low. Some of us, just with Social Security, maybe a small pension or your IRA RMD or your 401k RMD, or maybe you have VA pension money coming in, that can easily pop you over that amount. And if you are one penny over that amount, you will not qualify for Medicaid. And you will need to have what's called a qualified income trust done. And it's a special kind of trust that allows someone who's over income to qualify for Medicaid nonetheless. Here's where we have the problem. Typically, when someone comes to me and says, I need to help my husband, my wife, my mother, my father, my sister, my brother get into nursing home, and we have just found out from the business office at the nursing home that they are running out of Medicare days. So I don't know if you know this or not, but Medicare does not pay for long-term care. Medicare will pay some time for rehab. If you had to go into the hospital and then go to a rehab center, Medicare will pay for a certain amount of days, but Medicare is not going to pay for long-term care. And long-term care is nursing home care usually. So that's when they usually call us, because they've been handed a bill for next month. And the bill is going to be $10, $12, $14, $17,000, depending on the facility you go to. There's some are less expensive than others. And that is a shock to the system when you get that bill. And usually when we get called, we are dealing with a crisis. We need to get Medicaid approved right away because they can't afford to pay the bill. So we scramble, a lot of scrambling. The first thing I will ask is, does your husband, spouse, or whoever it is that's going into the nursing home, do they have a durable power of attorney? I need to know if you, the person in front of me, has the legal ability to do this for them. Number one, do you have the authority to help your mom, your dad, your sister, your brother, your spouse, even? And if the answer to that question is no, my next question is going to be, do they still have the mental capacity to sign legal documents? If the answer is yes, then we will do whatever we need to do to help you with getting documents set up, even if that means us driving to the nursing home, to the hospital, to wherever the person at, as long as they're in Brevard County, to help that with signing and getting legal documents updated. If they say no, they don't have capacity, and I find out that there's certain techniques I'm going to have to do to get them qualified for Medicaid that will require a durable power of attorney or other type of authority to do, then the next step will be, well, since they don't have capacity, since there's certain work that needs to be done that will require you to have the authority to do the work for them, and they don't have a durable power of attorney that allows you to do that, then I am going to have to file for guardianship for you, for your loved one. And we will have to, once the guardianship is established, ask the court for permission to do the Medicaid planning for you that you need so desperately. The problem with that is it's time consuming, number one, because you're dealing with the courts. And anytime you deal with the courts, time slows down. Okay? So we want to try to avoid the courts. And I could just simply avoid it just if I had that durable power of attorney. The other reason why you don't want to go through guardianship is because it's very pricey. It's very expensive. A typical guardianship will probably cost you about $7,500 to $10,000 just to establish. And then guardianships last usually for the lifetime of that person. And there are requirements that you have to do every year, and you have to have an attorney. It's required. So the cost of the guardianship doesn't go away until the person dies. Okay, so we want to avoid guardianship, and we avoid guardianship by making sure we have proper legal documents in place that will allow someone to be able to help make healthcare decisions for you and legal decisions for you. Okay. So we want to be proactive. That is the biggest thing when it comes to crisis planning. If you come to me in a crisis, I am going to move hell and high water to help you and help resolve whatever the problem is, help preserve his assets as much as possible, help preserve your estate plan, help make sure there's someone in place to take care of you. I will do everything under my power. But the problem with crisis work is you have less options usually, okay? And everything is quick. So we have to work really fast. It's very stressful for all concerned. And you may not have as many options available because of the time crunch. So we want to avoid that. And that's why I'm here today, to help you with getting your ducks in a row so that if there is a crisis, you have at least one stress that you're not going to have to deal with. And that is the legal authority of someone to help you through the process. So, I don't know where I'm pointing. Where do I point this thing? Oh, I'm pointing a laser. Jiminy Cricket. Okay. So one of the things to do to avoid a crisis or to plan for a possible crisis when it comes to elder law, right? There's all kinds of crises to plan for, hurricanes, all sorts of things. That's why we buy insurance. That's part of crisis planning. But for me, in elder law, crisis planning means let's make sure you have the legal documents you need. So I look at estate planning for that. And when a client comes to me for just a regular estate planning consultation, not even a crisis going on, not even a hint of crisis going on, just a regular estate planning consultation, I want to know two things. Who is going to take care of my client if they lose capacity and cannot take care of themselves? Number one. And then number two, how are we going to carry out my client's wishes when it comes to their things after they pass, like taking care of their family? Maybe they have a disabled child I need to think about. Maybe they have a disabled spouse that I need to think about. And also part of that, the part B part about what do we do with your things and how do we treat your things and make sure your wishes are carried out. I also want to avoid probate for you if possible. Okay, so probate is another court procedure, also pricey, also time consuming, and is completely avoidable most of the time if you plan for it. So to avoid guardianship, we're going to plan for it by making sure you have certain documents in place. To avoid probate, same thing. We just make sure that you have certain documents in place. And part B to that is making sure that your assets are either structured in a way to avoid probate or they're held in a certain manner to avoid probate. So what I mean by that is maybe bank accounts. If you have a very simple plan, nothing crazy going on, and you just have like one kid or two kids or a spouse, you can just name them as a beneficiary in your bank accounts. You can just name them as a beneficiary on your life insurance or on your 401k or other types of accounts. And that will avoid probate. But if you have any hiccups going on in your family, if you have a disabled person that you want to leave money to, or if you have a child, anyone under the age of 18 that you want to leave money to, you have to probably think a little bit more about it, because if you leave money to your grandkids, and I know I want to leave money to my grandkids, but I do not want them to have to go through guardianship to get the money I want to leave them. And why do I say that? Because in Florida, if you leave a child money that is in excess of $15,000, in order for them to have access to that money, they'll have to go through guardianship. Now, does that even make sense? When guardianship in that situation is probably going to cost $3,500 to $5,000 to get set up, right? So if you're only going to leave them a small gift, and half of it or a big portion of it's going to be eaten up in attorney's fees because you didn't plan it right. So that's something else that I think about when my client talks to me and says, here's how I want to structure my assets after I'm gone. I'll ask about each beneficiary, and is there any reason why we can't just give that money straight to them? All right. So one of the tools that we'll use in our toolbox when we do estate planning is a revocable trust. We'll use a revocable trust to hold assets in. You don't have to be rich. People think, a trust, that's only for rich people. No, that's for people who want to avoid probate. It's also used to help avoid guardianship, because whatever assets the trust owns right now, if you lose capacity and can no longer be the trustee of your own trust, well, that's okay, because you have probably named somebody to take over, step into your shoes as your successor trustee. That helps avoid guardianship while you're alive if you lose capacity. And then after you pass, whatever the trust owns can be distributed in the manner you want without having to go through probate. So it's a win-win. Revocable trusts are very helpful. If people have certain assets that I know are going to require some special planning to avoid probate, I'll often talk to them about a revocable trust. If you're going to leave assets to a child under the age of 18, I'll talk to them about a trust. These are ways to avoid guardianships and probates. So typically, if you own a home, a trust is maybe a good idea. Maybe. It's case by case. I'm not going to say blanket everyone that owns a home needs a trust because that's not accurate. Okay. So the next document, very common and most common document in estate planning is the last will and testament. Everybody's familiar with that. We use that document to say, do I want to be cremated? Do I want to be buried? Who's going to be in charge of my estate? This is how I want my stuff divided up. But please understand, wills do not avoid probate. If you have a will, your assets will be distributed the way you set it up in your will, but it will likely, depending on the asset, but likely will need to go through probate. And if you can avoid probate, you should. Now, if you get a trust, you will still get a will, but it's a special kind of will. It's called a pour-over will, and it's designed to work with your trust. And what I mean by pour-over is just what it sounds like. It pours over into your trust. And then the trust does all the heavy lifting, and that could be a way also to avoid probate when you have a trust and they work together. The next document, and I've already mentioned this probably a half dozen times, is the durable power of attorney. To me, that is the number one most important document a person over the age of 18 can have to avoid guardianship. I take care of guardianships for children who have been abandoned or orphaned. So I have guardianship clients from infants all the way up to 100 years old and every age in between. But this particular type of guardianship that I'm talking about is the kind of guardianship that happens to someone who's over the age of 18 and they lose mental capacity for some reason. Usually, if it's a younger person, it's because of an accident. I've had very young people that I've had to do guardianships for, 17, 18 years old, because of accidents. And it's very sad. But when you have young children and they're turning 18, I always talk to parents of young adults and say, hey, I'm not thinking that your 18-year-old needs to have a will and a trust and a blah, blah, blah. They don't need anything like that. But I would recommend that anyone over the age of 18 should have a durable power of attorney and a healthcare surrogate because you do not know what the future could hold. Accidents happen to everybody. But this document is the number one document to keep you out of guardianship if you were to lose capacity due to a health incident, due to an accident, due to just about anything that would affect your capacity. And then they're relatively inexpensive when compared to the cost of a guardianship. And it also protects your privacy because I didn't mention this, but guardianship means the government is in your business intimately. And who wants that? I don't. All right. So the next document is the designation of healthcare surrogate. That is the number two most important document to keep you out of guardianship. This is just what it sounds like. You are designating someone to make healthcare decisions for you. A well-written designation is also going to include HIPAA release information that will allow the doctors to talk to you about your loved one. It'll allow you to pick up medical records. A healthcare surrogate is going to allow you, a well-written one will allow you to make all sorts of healthcare decisions from what doctors to see, what medications to use, what type of procedures to get, what nursing home you go to, from everything from should I put my loved one on life support or should I take my loved one off? A good document will allow for all that power. The next document is a living will, and this can sometimes be misconstrued and misunderstood and confused with a last will and testament. This document is not the same thing as a last will and testament. This document is about end-of-life care, and it really speaks for you in the event that you cannot speak for yourself, you're unable to communicate, and you're in the active dying process, and 2 doctors have determined you to be in the active dying process, this document speaks for you. It can be edited any way you want it to be edited. It can be edited to fit your religious beliefs. But in a nutshell, typically it's going to say, keep me comfortable, give me pain medication, but don't plug me into machinery and don't keep me alive artificially. That's a typical living will. The next document is what I call the Plan B. We do not want you in a guardianship. We are going to do everything we can to keep you out of guardianship, but in the event that you need one anyway, this is a declaration naming pre-need guardian, and what it does 2 things. You can use it to state who you would want if you had to have a guardian, and sometimes more importantly, you can use it to say who you do not want as your guardian. Because almost every family has somebody in the family that you love them dearly, but you do not want them making decisions for you. So you can name them as someone that's disqualified. And again, this document is just a Plan B. And typically someone who has all their ducks in a row and has all their documents in place, and they have beautifully written documents, and it should do everything you need it to do to avoid guardianship. This typical scenario that causes someone in that predicament, that situation, to still need a guardianship are your children. Yeah, your children. Usually it's a power struggle issue. One kid doesn't like what's happening, doesn't like that the other kid's in charge, and so they hire an attorney to upset the apple cart and do what I call a hostile takeover. But this document can squelch that. If you know who the possible hostile takeover person may be, you can just name them and disqualify them. So planning pitfalls, Kerry touched on that a little bit. Yes, I have reviewed documents that were drafted by a criminal law attorney, and they were atrocious. And they were done by a criminal law attorney that practices law less than a mile from my office. I know him very well. And I told him, this was terrible. You're lucky that I got involved because I'm going to fix this problem. But you pretty much committed legal malpractice here. Don't do this anymore. Stick to criminal law. And he thanked me for that. But anyway, if you have your documents drafted by someone other than someone an attorney who practices regularly in estate planning, you may want to have your documents looked at. If you have documents that are over 3 to 5 years old, you should have them looked at periodically. It's recommended every 3 to 5 years. Occasionally, the law changes, and it could affect the way your documents are able to be used. That's the reason for that 3 to 5 year review. But if you have out-of-state documents, you moved in from out-of-state, brought in your old documents, definitely get them up to date with Florida-specific documents so that you have what you need when the time comes. If you did it yourself, you downloaded your documents from the internet, you need to have your documents probably redone. If you went to a paralegal service, a place that is independent from an attorney, you probably need to get your documents redone as well. I've seen documents drafted by all these types of people, all these types of entities that are problematic, especially when it comes to Medicaid planning. Because like I said, I'm looking for certain authority to be able to do Medicaid planning. And I'm going to tell you right now, if you had a power of attorney drafted by Patrick Air Force Base and you need a qualified income trust when it comes time to do your Medicaid planning because you're over income, you're going to have a real problem with that power of attorney because it does not give Medicaid powers. In Florida in 2011, certain powers became what's known as superpowers. And these superpowers have to be initialed, and they have to be initialed next to the superpower. So sometimes you'll get these out-of-state powers of attorney where it'll say power A, B, C, D, E, F, G, and then down at the bottom it says, I grant all those powers, all of the above. Well, Florida says, You cannot do the all of the above option. Florida is specific and says you must initial next to each power. So that logistically becomes a problematic document when it comes time to use it in Florida. So these are all pitfalls to watch out for. And if you feel like you have any nervous belly going on over any of these, just have your documents looked at. Okay. What happens if you don't? What could happen if I don't have a crisis plan? Well, you could end up in a guardianship. It could delay the whole process, especially if you're going into a nursing home and you're getting that big bill. It could end up costing more because you might have to privately pay that bill while we try to get you ready for Medicaid because of the delay. Also, if you don't have documents in place, not only could it be a problem with guardianship, if you pass away and you don't have documents in place, then the state of Florida has a plan for your estate, and it may not be the plan that you would have chosen for yourself. So it's better to have your own plan, put it in writing. Okay. And what if you already have estate planning documents? So I kind of already touched on that. You should have them looked at, especially if they're out of state, if they're old. If anyone that you named in your documents to be in charge of anything has lost capacity, has died, or you simply just don't like them anymore, get your documents updated. And how not to go broke when faced with the crisis of nursing home care. That's a big one. And that's where Medicaid planning comes in, because nursing home care is expensive. So we do Medicaid planning to get people on Medicaid. Medicaid will pay for nursing home care. Medicaid will pay for your time in the nursing home, the care that you need, and your room and board if you have to go in the nursing home. So what this tells you is the cost of care, home care services, $4,500 a month, and maybe more than that. That might be it depends on how much services you need, frankly. But that's usually someone that's going to come in, help with some housekeeping, maybe do some laundry, cooking, light things, not nursing, not hands-on nursing. They might help you take a shower, things like that. Assisted living care. This one says $5,200. I'm going to tell you, you may be able to find some assisted livings for that price. But the real nice, fancy ones, the ones that we see, and they're like, wow, like Zaun, great place, but it's not going to cost you $5,200 there. It's going to cost you significantly more. And also, it depends on how much care you need, how much assistance you need as to how much they're going to charge you. And then nursing home, semi-private. Semi-private is just a nice way of saying you're going to have a roommate. This price is from 2021. It says $7,900 a month, and I think that's low even for 2021. And you're not going to find that in Brevard County. That no way. It's going to be $12,000 or more a month for a semi-private room. If you want a private room, it's probably going to be $15,000, right? Yeah, about $15,000 or so a month. It gets quite pricey. So how do we pay for this? Well, there's 3 ways to pay for care. You either are going to purchase long-term care insurance, which I don't sell, but you can purchase from most places that sell life insurance and that type of insurance. But long-term care insurance can help keep you at home longer, help pay for care to keep you at home longer. Or if you end up going into a facility, it could help offset the cost of care there as well. So it can be helpful. Self-pay, that's great if you got enough money to self-pay. But the majority of people in nursing homes, 50% or more, are going to be getting paid for their care through Medicaid. Now, Medicaid is unique because Medicaid, although it's a federal program, it's handled by every state. So every state has their own rules, their own ways of doing things. So how, say New York, how they do their Medicaid is going to be really different than how Florida does its Medicaid. So If you have stories of Medicaid from other places, it is probably not going to apply here in Florida, just so you know. And also, listening to your neighbor down the road about their situation is not necessarily how it would go for you. Because it's case by case. But Medicaid is the major payer of nursing home care in the whole United States. Medicaid has a means test, which means that we will be, as part of the application process, I do applications. I help people apply for Medicaid. I help them prepare ahead of time to make sure when we do the application that you get approved. And so we will be looking at your income and we will be looking at your assets. And when we look at your assets, we look at each asset and we try to decide, how do we treat this asset? So there are asset limits. And in Florida, if you're a single person or a married person, the sick married person going into the nursing home or the single person cannot have more than $2,000 of countable assets. All right? $2,000. Now, the default rule is all assets count. There are a few exceptions. One homestead up to $713,000 in equity won't count. One car won't count. A second car, as long as it's old, 7 years old or older, not a luxury or collector's item, won't count. There's certain burial counts that don't count, burial contracts that won't count. But we look at each asset individually and decide, does this count or does this not count? So we have two columns, countable versus not countable. And then it doesn't count, so we don't care, right? No. Do you know why I still care about the assets that don't count? Because I'm looking long term. Yes, I'll get you on Medicaid, but I don't want Medicaid to come back after you pass away and try to take your house. I'm going to want to help avoid that situation as well, because in the state of Florida, if somebody passes away, we are required by law to report your death, if you're over 55 years old, to the state of Florida. We are required to report your death to the Department of Revenue specifically. And why is that? Well, that's because they are going to go dig through their records and they're going to go see, did you collect any Medicaid benefits? And if you did, in your probate, now I'm not required to report your death, period. I'm only required to report your death if I'm filing a probate. Okay? So if I have to file probate because we didn't take care of your assets, or you didn't take care of your assets, and now we have to have a probate, and you are over 55 when you die, we have to report it to the Department of Revenue. They're going to check their records to see if you received any Medicaid benefits, and if you did, they're going to file a claim in your estate to recover the Medicaid assets you received. So if you were in a nursing home, and the average stay in a nursing home is 3 years, $10,000 to $15,000 a month, add it up. It could be a lot of money. It could be a big claim. And they find out you filed a a probate, so now they're filing a claim, and now we got to deal with this Medicaid payback claim. And I want to avoid that. So when I'm going through the assets, figuring out, does it count? If it doesn't count, I want to make sure we have a plan for what to do with the assets that don't count so it doesn't go through probate. So we do one asset at a time, figure out, how do we avoid probate with this asset? One asset at a time. It's very time consuming, but it's worth it. All right. And then what do we do with the assets that count if you're over $2,000 in countable assets? Well, we figure out, is there a way for us to legally take this asset that counts and convert it into an asset that doesn't count? And again, we do it one asset at a time. And we talk to you, tell you about your different options. And then you pick your poison and we move forward. But our goal always is to preserve assets, to preserve, because the number one thing I want to do, especially for a married person, is I want your spouse, your healthy spouse, to not be destitute. I want the healthy spouse that is not going into the nursing home to be able to support themselves. And then for a single person, they may not have a spouse to support, but they may have disabled children, or they may have other situations at home. And so I'm going to want to make sure that we're doing our best to protect the family through this process as well. All right, so we do have Medicaid myths, and I'll let you read those at home. But number one, I had a question earlier. Can I just add my kid to an asset to avoid a problem with Medicaid? No. If you add your kid to the deed of your house to avoid probate, that's a problem, because Medicaid is going to look at it and say, that was a gift, you're disqualified. Now, if you give away money or you add your kid to your bank account, that's a problem too, because now it's considered a gift, possibly. So you have to be really careful. There are ways to make sure Medicaid doesn't get these assets, but there's lots of rules that have to be followed, and it's asset by asset. But please take your time to read those myths. I gave you a whole handout on them. Don't hide your assets. Don't give your assets away. Don't sell them for less than fair market value. Don't do Medicaid on your own, Medicaid planning on your own, because likely you will do something wrong and then you'll be disqualified from Medicaid, because Medicaid can look back up to 5 years from the time that you push that button and say, I want to submit my application. Ding. They can now search your history for 5 years to find out, did you give away any assets? Oh, and if you put assets into a trust, that's a disqualifying event. So, yes, assets in trust count unless they're in an irrevocable trust. And most people are not going to be using an irrevocable trust because they don't want to give up the ability to manage their assets. So read the myths, and it'll help open your eyes to a lot of things. Medicare does not pay for long-term care either, and that's one of the myths that people think. So how can an elder law attorney help? Well, elder law attorneys such as myself, we are very well versed in the Medicaid rules. Not every attorney understands Medicaid rules. In fact, I'm going to tell you that only elder law attorneys understand Medicaid rules because nobody else deals with them. Nobody else deals with them except us. So it's not something that your family law attorney can help you with, or God forbid, your criminal law attorney. It really is a specialty, and you should talk to an elder law attorney if you are thinking that you may one day need to get long-term care and you don't want to go broke doing it. All right. So then lastly, I open the floor up for questions. I can take just a couple because I have like 3 minutes. Karen, right. So the old adage has a lot of wisdom to it. An ounce of prevention is worth a pound of cure, right? And there's another one. Don't be penny wise and dollar foolish, whatever it is. Yeah. Pound foolish. Yes. So trying to save a little money, I'm going to tell you, I have had situations where people have downloaded their own documents, and 9 times out of 10, I have never seen a do-it-yourself set of documents that have been good. I'm just going to say I've been doing this a long time, and I've not yet seen a do-it-yourself set of documents that are good. There's some that are maybe adequate, but the problem is you don't know usually that you have a problem with your documents until you try to use them. And when do you try to use them? Well, usually it's because your loved one has lost capacity, and now you're going down to the bank and you're saying, here's my power of attorney. And they look at it and they go, sorry. They'll send it off to legal. legal may or may not approve it. And in Florida, word to the wise is if your power of attorney does not state specifically that you can do something, there is no power to do it. So you might have downloaded documents. You might have even paid one of those online services to do documents for pennies on the dollar. But if you end up not being able to use those documents and I have to file guardianship, I just told you $7,500 to $10,000. And I'm going to tell you, there is I might have done a $7,500 estate plan, but I'm going to tell you, that was for like a multimillionaire. They had all kinds of things going on, crazy stuff going on. Most people, I'm not spending anywhere near that on their estate plan. Sir?
What if all property in multiple states and you're a resident outside of Florida?
Are you a Florida resident?
No. I was raised here.
Okay.
You're on the law.
So wherever you are a resident of, whatever state you're a resident of, you should have your documents done by an attorney from that state. So if the situation was reversed and you said, I am a Florida resident and I own property in other states, I would say to you, okay, Florida resident, we can set up a Florida trust for you. We can put your Florida property into the trust to avoid probate. And then I will need you to talk to your attorney in whatever the states are that you have other property. And I'm going to give you information to give to that attorney. And they will put your property that's out of state into this Florida trust and it will avoid probate. I do not practice outside of the state of Florida. That's why I don't do those deeds. And I can't answer for other states, but I would presume, and that might be a dangerous thing to do, but I would presume that your out-of-state attorney, elder law, make sure it's elder law attorney, could probably do the same thing from their state and then put your properties in there. The problem that I find is a lot of other states have estate taxes. So I highly encourage you to choose a different state for your major residence, Florida, because we don't have estate taxes here, and we have a lot more flexibility with regard to that. Who has any other questions? I'll take one more, and then I'm going to have to hand the floor over to that young man over there. Ma'am.
Curious about HIPAA laws. You mentioned that you go over. So how do you take over when a spouse, it's hard for us doing any business and we're married and the HIPAA laws always come into play?
Well, that's where that designation of healthcare surrogate comes in, because if you have a well-written healthcare surrogate document, it's going to have a HIPAA release inside the document. And then that way you have it and they can talk to you. Okay, I am going to be available back there at that table for any final questions after we're all done. But I think there's another speaker coming up that Kerry's going to introduce.
Thank you, Ruth Rhodes. Every time I get to hear Ruth speak, I learn new twists and things. I've heard several parts of this, but it's so complicated. You understand why this is, do not try this on your own.
I'm Joe Steckler. Thank you for joining our program today. I'd like to remind you that our senior information line is available to you at 321-473-7770. There you can get help and direction that could be helpful for your specific situation or circumstances. The work of helping seniors is very important, but we can't do it alone. That is why our sponsors here in Brevard County are so important. I'd like to thank our many area sponsors, businesses, and medical providers who support the mission of helping seniors that help us carry the cost of our media efforts. If you'd like to join us either as a business partner or simply donate as an individual, we welcome your call at 321-473-7770. You are always welcome to visit our website at www.helpingseniors.brevard.org. Thanks so much for your help. It does make a difference.